Hi, I'm Lucy. I'm a partner in Brodie's Restructuring and Insolvency team. As you may know, we're doing a social media takeover this week, and we're sharing insights in relation to restructuring insolvency matters that you may be seeing in the media. In today's session, we're doing a Q&A in relation to lessons that we've learned throughout our careers in insolvency. I'm joined by my colleague Jamie Nellany. Jamie's a senior associate within our team. Jamie, do you want to tell us a little bit about the experience that you've got in restructuring insolvency?
Yeah, sure. Thanks, Lucy. So I've been a restructuring lawyer in Scotland for over 12 years. I advise businesses, lenders and insolvency practitioners at really all stages of financial distress and across a wide range of sectors.
Thanks, Jamie. So as we know, at the moment, we're hearing an awful lot in the press about insolvency and businesses are facing insolvency. What are the signs that a business may be in financial difficulty? And if they find themselves in financial difficulty, what steps can they take?
Well, at the moment, the measures that have been put in place by the UK and the Scottish governments to support businesses impacted by the global pandemic are, I would say, to somewhat masking the usual triggers or signs for insolvency. The typical signs are a ramping up of pressure from one or more creditors. And so if there's bank lending there, then that might be an increased level of monitoring from the bank, possibly leading to a request for repayment proposals. If there's arrears owed to HMRC and perhaps a time to pay arrangement hasn't been complied with, or perhaps a trade creditor is threatening court. That's what you would typically expect to see. At the moment, due to the temporary measures in place, well, you've got additional liquidity in the market through the government support lending schemes, CBILS and Bounce Back in particular. There's legislation in place temporarily suspending winding up petitions. And I think generally lenders and HMRC are giving businesses more forbearance perhaps than they ordinarily would. But it's important for businesses to be thinking about the fact that these measures will not last forever, and at some point the government is going to have to start recovering the funds that they've put out. So we think it's important for businesses to try and consider where they will be in 6 or 12 months' time. Now, I realise that for some this will be extremely difficult. The situation can be changing for them on a daily basis. But for others, there will be some steps that that can be taken to forecast our best and worst case scenarios into next year. And this is also where advisors can help, both solicitors and accountants. And another thing is to try and look at your suppliers and customers too. Now is very much the time to have conversations with these stakeholders and to put any plans in place before this time of support starts to come to an end. So and I think a point we would make is that we would very much rather help businesses avoid insolvency than be dealing with them in a winding up situation.
I think that's absolutely right. I guess that if you are a business and you have gone through all the processes of trying to restructure your debts and try and avoid formal insolvency, in the event that you cannot avoid formal insolvency and some formal appointment takes place, could you maybe talk us through about what that would look like and what maybe directors ought to expect on day one?
Yeah, sure. The different processes, the typical ones are administration, liquidation, and to a lesser extent receivership. They have subtle differences, but generally on day one, all of the management and control of the company transfers to the insolvency practitioner and their team. So, they will take control of speaking to the employees, the creditors, the customers of the business, and any day-to-day decisions, including whether to continue to trade, will be their responsibility. For most directors, this will clearly be a stressful time, but there can also be a sense of relief that perhaps a weight has been lifted. Each situation is different, each company is different. There will always be a conversation with the insolvency practitioner as to what extent directors and perhaps key employees maybe stay involved in the business and the process, and that will very much depend on the situation. I suppose talking about the role of the insolvency practitioner, at a sort of basic high level, is to gather in the company's assets and realise them for the best interests of the creditors. So if it's a trading business, then the IP may have to decide very quickly whether to continue to trade. And this will be a weighing up of the risks of increasing the company's debts as against the prospect of achieving a better sale. Additional funding might be available, potentially by the lender that's already there, but perhaps maybe by a prospective purchaser. And also, it's worth bearing in mind that the management themselves might be interested in buying back some or all of the business. And in that case, the insolvency practitioner may run an accelerated marketing process. They will have people who they can go out and contact who might be interested in buying some or all of the business. And they would then set a closing date for offers. And all of this can happen in a very quick time scale. It could be a matter of days. And I suppose another possibility is a pre-pack sale. And that's where a sale of the business or some of the business is negotiated by the insolvency practitioner before they are appointed, and it's then immediately completed once the appointment goes ahead. So the main benefits of a pre-pack sale are, I suppose, to minimise the potential erosion of the business that might be caused by administration. But it also might be the only option, because going back to that funding question, or the issue of funding, if there is no funding, then there is no ability for an IP to actually trade the business. So the only option might be to negotiate a sale pre-appointment. Mm-hmm. So, Lucy, if I can ask you a question, there's historically been a stigma, I think, attached to insolvency, which has been eroded in recent years. Mm-hmm. I'm wondering what your thoughts on the impact of the pandemic will be on any negative perception of insolvency.
Yeah, thanks, Jamie. I think that's quite an interesting question. I do agree that in terms of stigma, I think that the stigma around insolvency has eroded over the last number of years. And I think, though, that with the COVID and the pandemic itself, I think it's a real leveller. And I think that what people are recognising is that businesses are not in trouble as a result of what was normally or traditionally the perception of poor financial management or mismanagement, which led to insolvency. Instead, what we have is a situation where businesses find themselves in the position that they are as a result of measures which have been taken by government, and they find themselves in an economic situation which is entirely out with their control. Businesses which were highly successful immediately prior to the lockdown restrictions are now finding themselves under significant financial pressure. And I think that as a result of that, not only do businesses themselves but also the public recognise that we've got extremely entrepreneurial, hard-working people within our business community, and it's not through any fault of their own that they find themselves in the position that they are. They are here simply as a result of government measures and government policy that have been designed to put them in the position that they are. And so from that perspective, I think that the stigma will be eroded. I think that, as you and I both know, being advisors to businesses who are in financial distress, it's an extremely stressful situation for people. And I think that there's a real human aspect of that. And I guess that, from our perspective, there's certainly no stigma attached at all. And I think that what is important, though, for directors and boards of directors of companies is to actually be responsible at the earlier stage that they possibly can be. And I know that often what people are thinking about when they find themselves in financial difficulty is that they're concerned about employees, they're concerned about stakeholders in their business, and often we're looking at businesses who have it's been people's lives' work, and it's also or their families' lives' work. And I think that we understand from the work that we do that these are very difficult and emotional situations that people find themselves in. And I think that, back to the point that you made earlier about taking advice early and taking advice from advisors, I think that just points to me that what you need to have on your side is someone that's able to help navigate through these difficult waters. It's a stressful time, but you need people who actually understand the processes and the regimes and can come up with practical solutions to help you through that. And I think the other thing, just kind of touching on what you'd said about the different restructuring tools that are available, I think that's important to remember that, fair enough, insolvency can be a very final and finite process, but I think you have to also accept that it may simply be the closing of one chapter and the opening up of a new story. And I think that from those perspectives, you have to think about it in the round. And so I think that it's important that people just take advice early and see, because that's the way in which you can increase the number of options that are available to you as a business and a business owner. So hopefully you found this of interest today, but if you do have any questions of either Jamie or I, or you wish to explore any of the things that we've discussed further, then please look at our restructuring and insolvency page on brodies.com. Thank you.
Thanks, Lucy.